Hi, this is Zach Herschensohn. I'm the host of the Zach Herschensohn podcast. We provide content for personal injury clients and also for personal injury attorneys. Um, Occasionally, I have guests. Sometimes it's just me talking, and it is of varying lengths depending on the day. Today, the subject matter for the podcast is a concept or a legal principle called statutory agency, or also referred to as the Hobson-Sinclair doctrine. This is a principle that's found for liability purposes in Jones Act claims. So these are maritime claims, injuries that occur at sea to people serving in an occupational capacity as a member of crew, and also in FELA claims, Federal Employer Liability Act claims, occurring on when people are serving on railroads, when they're working for the railroads. So those are the two areas that this concept comes into play. And I will be talking with more focus on the Jones Act claims, but they really are no different in as far as how the principle is employed, right? So a little bit of context uh, about my firm and what we do and how it is that I am prepared to talk about this concept today. So we have, my name is Zach Herschensohn. We have, I'm the owner and principal of Herschensohn Law. We're a personal injury firm with our main headquarters uh, in Kent, Washington. We have two other offices presently, one in Graham, Washington, and the other one in Ellensburg, Washington. And the focus that we have is on personal injury. We currently represent about 180 clients. And the greatest proportion of those from a numerical standpoint are car accident claims, but we also do maritime Jones Act injury claims. And historically, myself personally, I've done a lot of maritime litigation. So we do these cases. Though they are not numerically a great proportion of our cases, they are oftentimes some of the largest claims in terms of settlements. And so this has been a part of my practice for probably going on 18 years that I've done maritime claims. I think the first time I did a maritime claim was in, like 2007. Yeah, so 2007. So that's, yeah, about 17 years ago. And ever since then, it's always been a part of my practice. And at one point, it was maybe 90% of my practice. So it was like most all my cases were maritime claims. And over the years, it's become a smaller portion of it numerically, but there's always been a large part of the practice that's been maritime claims. And I've had recently, I had a very significant case. I'm actually still involved in the case that has to do with this Hobson-Sinclair doctrine. And so, since it's a very interesting area of and very specific area of Jones Act litigation, I thought it would be a good topic to discuss on the podcast because there may be practitioners who are evaluating claims and not be aware that they might have a case that could be brought against the employer, against the Jones Act employer, and they might completely overlook the opportunity they have there to bring a cause of action under the Jones Act. So a little bit of background with regard to the Jones Act, and then I will use that as the launch pad for describing statutory agency. So for those practitioners who are not aware, people who work in an occupational capacity as a member of a crew of a vessel on the navigable waterways of the United States are not protected by any sort of workers' compensation scheme in terms of getting recovery when they're injured at work. So as you are certainly aware, most people who are working in the United States are provided coverage for injuries that occur on the job by workers' compensation schemes. And there's different ones depending upon the workplace that you're in. Just by way of example, not an exhaustive example, but just by way of example, people who work shoreside in, for example, Washington State are covered for the most part by the Washington Workers' Comp Scheme, which is found at Title 51. Most other states have similar schemes where someone gets hurt at work, they don't have to prove negligence, and they are limited in their recovery to things like wage loss and medical bills, and maybe a small permanent partial disability award, but they also don't have to prove liability, and they get their benefits if the system's working well without a litigation. So that's the current scheme. Other types of workers, for example, people who work in a longshore capacity, so people who work in shipyards and so forth are covered under the Longshore Act. People who are federal employees are generally covered under the FECA, Federal Employers Compensation Act. And there are some variations there. Now, so the Jones Act is what covers people who work at sea. So if you're working at sea, generally speaking, if you're a member of a crew, you're going to be covered by the Jones Act. The Jones Act was passed in 1921. The Jones Act itself is a omnibus, large piece of legislation, and it covers a lot of different subjects, including some that are frequently up for discussion when there are things like hurricanes, where, and I believe the Trump administration at one point did suspend the Jones Act during one of the more recent hurricanes that involved Puerto Rico, because the Jones Act has provisions that prevent coastwise vessels, meaning vessels that go from one American port to another, to not have an all-American crew. So that can cause some issues. There are a lot of rules that are in the Jones Act that people think are inefficient and so forth, which is a topic not for this video. But the important aspect of the Jones Act as it relates to injury-related claims is that when they passed the Jones Act in 1921, there was no provision, no statutory provision that provided for a right to sue one's employer if you were working as a member of a crew. And I'm simplifying things for the purposes of this video. But in 1921, they passed the Jones Act, and what the Jones Act did was it adopted the FELA, which is the other class of workers who do not have a workers' compensation scheme in the United States. And that FELA, which is the Federal Employers Liability Act, that is the statute that provides coverage for rail workers. So if you work for any rail company, and there are some stipulations where the rail company wouldn't be subject to FELA jurisdiction, but most are, just for simplification purposes. We'll leave it at that. So they adopted that statute in 1921. And so that's the same statute. So both rail workers and marine workers are covered by the FELA. And when they discuss, in the vernacular of the way in which lawyers discuss the injury provisions of the FELA in the context of a marine worker, it's usually referred to as the Jones Act, even though there's all these other things that have to do with the Jones Act. The important principle here with regard to the Jones Act is that it's not like comp, in that if you as a practitioner have a Jones Act claim and you've got a good liability case, meaning liability is there, and that's another topic I'll bring up in just a second, that you have liability, meaning you have a negligence case against the employer, you can recover all of the damages that you might be able to recover in a conventional personal injury claim. So pain and suffering, wage loss, both past and future, medical expenses, future medical expenses, and I was perhaps some disputed medical past wages, or rather past medical expenses. But just like you have a regular tort case, that's what you have in a Jones Act claim. So you have potentially, if the injuries are significant, you have a really good case, because almost all marine employers have enormously huge commercial policies. So if you've got someone who's significantly injured, you've got an employer that you can sue for negligence, and they have pretty much universally lots of money. So Jones Act litigation has always been a pretty active area of practice around here in the Western District of Washington, and specifically in King County, because there's nearly all of the Alaskan fisheries are fished by boats that are based out of the Puget Sound. There's some Alaskan, but most of them are here. So almost all that litigation takes place here in Seattle. And it's, like I said, it's been an area of my practice for a long time. There are also a number of commercial vessels that operate in the Puget Sound, notably the Washington State Ferries, which is the largest ferry system in the United States. And so that's a big area of litigation. There's also a lot of marine type of construction and things of that nature that takes place, because we're a marine state, a maritime state. So that's something that's happened quite a bit around here. So there's certainly, though, many other areas of the country where Jones Act litigation is a pretty big part of things. Definitely in the Gulf, in the Midwest, because the Great Lakes are considered part of the navigable waterways. So really anything that's on any of the major tributaries, for example, anything on the Mississippi, those are all considered the navigable waterways of the United States. So if you any of the large rivers where you perhaps have barges or other types of marine activity, someone who gets injured will have a claim against their employer. So as a practitioner, whatever part of the country you're in, then you will frequently have at least the potential to have a marine case come across your desk. And if you do, you wouldn't want to pass up the opportunity to make some money. And you could perhaps take it yourself, or you could definitely call up our office, because even if you're in another part of the country, we'd be happy to help. Certainly in this area of the country, we would be happy to help. And so this is a sort of a cursory review of this principle, which is exists in maritime Jones Act claims. So let's get started. As stated, if you have a situation where an employer of a marine employee of a marine employer is working, the employee has a right to sue their employer for negligence if they are working at the time they are injured, and if the defendant is negligent. Now, one of the other aspects of the Jones Act claim that make them so good from a practitioner standpoint is you have a very flexible theory of negligence that's applied to the employer. It's been called featherlight negligence. It's also been referred to as what they always call it, but it's a standard that's extremely favorable to a plaintiff. And the phrase goes something like this: if the negligence of the employer played any part, if ever so slight, even if in combination with other factors or contributing factors, then you should fine for the plaintiff. The instruction for the jury is extremely light, because you don't have to prove direct causation to one individual event. The negligence of the employer can be but one of multiple different causes, and you still have to fine for the plaintiff against the employer. The other important point is that when you have a Jones Act claim, you only bring the claim against the employer. Now, most of the time the person gets hurt on a boat. So there's really only one entity to sue. That's the boat, right? So like a lot of times this is like a non-issue. But if you have somehow multiple sources of potential negligence that are conspiring to cause someone's injury, still the claim is always against the employer. And of course, under the Jones Act, any of the agents of, and this is an important part for this principle of statutory agency, any of the agents of the employer are considered the employer, and of course, any of the employees are considered the employer. So if you're on the boat, someone other than your client was negligent, you've got a case, right? If you're off the boat and there's any negligence that can be inferred from any conduct on the part of the employer that contributed to the injuries that were sustained by the employee, then you got a case. So it's a very light, very liberal interpretation of what negligence is. And so as a consequence of that there are a lot of scenarios where someone gets hurt while they're in the service of the vessel, but in a normal context, they wouldn't necessarily be able to bring a cause of action. But because of the relaxed nature of the Jones Act, they're able to bring a claim. So I'll give you one example of this. This is from a railroad case. So I'll just refer to the, sort of maybe the most impressive case in terms of the flexibility of the negligence standard under the FPLA. So that case that I would cite you to is Gallic versus Baltimore, Oregon Railroad Company. And that's 372 US at 118 for the specific facts there. But I'll just summarize for you here. So in Gallic, a railroad employer was working near a pool of stagnant water on a railroad property, which was infested with vermin and insects. He received an insect bite that became infected, and then it required the amputation of his legs. So in that case, the lower court the defendant filed a summary judgment saying, wait, there's no direct evidence that this, unidentified bug at the workplace was what caused the infection of the legs. In other words, this guy got bitten by a bug, and his negligence theory was that, well, they had like pools of stagnant pools of water on the job site. Therefore, that was the dangerous condition, and that dangerous condition caused there to be more bugs, and then the bug bit him. Some bug bit him, and so the court said, no, you can't dismiss that case. There's plenty of evidence for the Jones Act, right? Because the court said there that the evidence that any employer negligence caused the harm is enough to justify the case going to the jury to determine the employer negligence, because the standard is whether the employer negligence played any role in producing the harm. That really is an example of just the very, very relaxed standard. Essentially, so the Gallic case essentially demonstrates that the standard is really, really low. That's probably the most attenuated set of facts that the Supreme Court has commented on, although there's a lot of cases out there that basically demonstrate the same fact, which is that you can have multiple different sources of the cause of an actual underlying injury, but it's always the jury's determination as to whether the negligence of the employer played any role in producing the harm. So what this means is that essentially you can almost get any case to a jury, whether the jury likes the case and awards some money, that's a different question, but you can pretty much get any case to a jury, right? So that makes them very favorable claims. You always have wage loss, right? So there's a lot of reasons that you want to be able to bring in a Jones Act claim. The other thing is you bring a Jones Act claim, like I said earlier, against the employer always. So if there are other entities that contributed to this injury, you don't have to bring them into the lawsuit. Now, the defendants can do that. The defendants can initiate third-party defense actions that can be, to pursue subrogation after the claim. There are a lot of sort of issues there, but in general, you're bringing this claim against the Jones Act employer, and the Jones Act employer has this very relaxed standard to prove. All right, so that's the setting for the Hobson-Sinclair doctrine. So what is the Hobson-Sinclair doctrine? What is statutory agency? So one of the aspects of the FELA Jones Act, and that was actually what was issued in the Gallic case, is that the employer has a non-delegable duty to maintain a safe working environment for its workers, right? And so this is their negligence standard. So anything that causes an unsafe condition at the workplace is considered negligence, right? Obviously, individual negligent acts are certainly considered negligence as well. So that is subsumed within this agency theory. And what the law says with regard to this issue is that the employer cannot delegate the obligation to provide a safe working environment. So that if the employer hires some other entity to provide a service for the employer in furtherance of the overall enterprise of the railroad or the maritime employer, then that negligence is imputed to the employer. Okay, so what this means is that anytime that the employer hires a third party to do some work on its behalf, that negligence is going to be imputed to the employer. Thanks for listening to the first part of the podcast focused on the Hobson-Sinclair doctrine. We will conclude the second half of this hopefully within the next several weeks. And I look forward to explaining more about this very interesting topic in maritime law. Thanks.